If a person is provoked sufficiently to kill someone else in a hot-blooded rage, a charge of murder could be reduced to manslaughter. In Dennis v. State, the court discussed what constitutes sufficient provocation. John Dennis and his wife Robin had a 12-year-old son. After the Dennises declared bankruptcy, Robin moved out. Dennis soon learned Robin was living with Mark Bantz, with whom she had a romantic relationship. This news upset Dennis, partly because he knew Bantz used drugs. About 2 months later, Dennis began to accept the situation and focus on raising his son. Then Robin said she wanted to come back. Dennis and Robin spent a couple of nights together, but Robin asked for more time to make a decision. One night, Dennis allowed their son to stay overnight with Robin. The next day, Dennis learned that Bantz had been present and had smoked cocaine around the boy. Dennis decided to investigate. When he couldn't reach Robin by phone, he drove to the house where she was staying. Dennis had a handgun with him. Dennis arrived at the house and looked through the window. He saw Bantz and Robin embracing. Robin's dress was hiked up. Dennis thought it looked like they were about to have sex. Dennis kicked in the door and shot Bantz 9 times, killing him. Dennis was charged with first-degree premeditated murder, among other offenses. At trial, Dennis requested a jury instruction on voluntary manslaughter based on adequate provocation. The trial court gave the requested instruction, telling the jury that adequate provocation would exist if Dennis found Robin in the act of sexual intercourse or had strong reason to believe that intercourse had recently occurred. Dennis was convicted of premeditated murder. Dennis appealed to the Maryland Court of Special Appeals, arguing that the contact he'd seen between Robin and Bantz was adequate provocation to support manslaughter, and that the jury should have been told that Bantz's drug use around Dennis's son was also sufficient provocation.